Hi, I'm here to explain who can apply for a patent and who can own a patent pursuant to Australian patent law. But first, some important background information. A patent and the protection it grants can be bought and sold, leased, gifted, or inherited like other items of personal property. Any assignment must be contained within a written agreement and signed by all parties to the transaction, although such formalities can be dispensed with if the assignment takes place prior to the lodgement of the patent application. Thus, patents originate by way of application, so the patent may be granted to any nominated person within that application. Patents are also granted by devolution of law, particularly when a nomination is disputed by others who feel they are entitled to the patent. So with that said, haven't you ever wondered who can apply for a patent? Any legal entity can apply, but only the following persons will be considered eligible for patent protection under Section 15 of the Patents Act. Where the person in the application is the inventor, or is entitled to have the patent assigned to them, or is deriving title from someone who already owns the patent, or is the legal representative on behalf of the patent owner's estate. If the person nominated in the patent request is not entitled, the grant may be opposed, or the patent may be revoked. Co-ownership is permitted by virtue of joint patent applications, where each inventor may seek separate patents for respective components of a single invention, or as co-owners of the whole invention as tenants in common. Therefore, interests within a patent are transferable between co-owners by assignment. And interestingly, ownership may be divided geographically within different states or countries. So, you've created an invention. Well done! Lucky for you, your singular genius secures your eligibility as the inventor. Let's now say you were a part of a team of inventors that have created a new product. Who would be granted the patent? If the nominee in the patent application is disputed, or in the absence of a joint patent application, assessing multiple contributions and their interrelationship to the invention can be complex. Discussed within JMBB and Camouflage, rights to the invention are assessed objectively by respective contributions to the invention. Essentially, if the final concept of an invention would not have come about without a particular person's involvement, that person is entitled to their interest in the patent. An example of this was seen within the delegate decision of Ralph G. Waters and Stratum Green, where overwhelming evidence showed that Waters and the patent owner, Hudson, had jointly created the invention. Their rubber bitumen surface invention would not have occurred without the contribution of Waters. Section 32 of the Patents Act provided a mechanism for the Commissioner of Patents to decide how or if the patent application should proceed. But due to the application being already approved, Section 36 allows for a person to apply for a declaration that the nominated person was not entitled to be the owner. By this time, Hudson had transferred his interest to Stratum Green Corp., but Waters' application was successful and co-ownership was subsequently awarded to Waters. A decision maker will carry out a detailed analysis of the contributions, and if deemed multiple people are worthy of joint inventorship, they shall be nominated under the amended patent application, possessing interests proportionate to their contributions and not necessarily as equals. There are other circumstances in which patent ownership can occur, such as within the course of employment. Employees are almost always required to sign employment contracts, which typically contain pre-assignment clauses. This means if you're at work and you conjure up an invention during the course of employment, or in the utilization of employer resources, you have approved the assignment of patent rights to your employer. Although the court has been found to void pre-assignment clauses if considered to create unreasonable restraints upon trade. In summary, anyone can apply for a patent as long as they are eligible. Patents may be jointly owned. Disputes between inventors and owners are settled through the devolution of law, and employers may have rights to inventions created during the course of employment. Thanks for watching.